Reading approval of the minutes.
Mr. Chair, I move to dispense also the reading of the minutes.
Any objection? There being none, reading of the minutes is hereby dispensed with. Distinguished members of the committee. Okay.
Mr. Chair,
Any
there are,
motion for the approval of the minutes of the previous September 24 and 25 meetings of the committee?
yes, Mr. Chair, I move for the approval of the minutes of September 24 and 25 of the previous meetings. So move, Mr. Chair.
No objection. There being none, minutes of the September 24 and 25 meetings of the committee are hereby approved. The chair will be having a brief remark for the guidance of those present. Distinguished members of the committee, esteemed colleagues, authors and sponsors of the various measures before us today, and our invited guests, resource persons, welcome to the third regular meeting of the Committee on Justice. We have several items in our agenda today. First is the approval of the committee reports on various bills we approved in our previous meetings relating to the creation of additional court salas all over the country. During our previous meeting, we heard the recommendations of the Office of the Court Administrator, the views of the Supreme Court, and we approved and amended the various bills based on recommendations of the Office of the Court Administrator. For approval today are the committee reports on the following measures. One is House Bill number 842, authored by Honorable Rufi Biazon, creating 5 additional branches of the RTC to be stationed in Muntinlupa. Another is House Bill number 1156, authored by Honorable Yeda Marie Romualdez and Majority Leader Ferdinand Martin Romualdez, creating 4 additional branches of the RTC in Tacloban. Next is House Bill number 1446, authored by the Honorable Manuel Antonio Zubiri, creating 1 additional RTC branch in the municipality of Quezon in Bukidnon. Also is House Bill number 1619, authored by the Honorable Representative Aleta Suarez, creating 3 additional RTC branches in Catanawan, Quezon. Also is House Bill number 2122, authored by the Honorable Representative Joaquin Chipeco Jr., creating 3 additional RTC branches in Calamba City, Laguna. We also have House Bill number 3091, authored by our former Speaker, Pantaleon Alvarez, Representatives Aldo Duhali and Roel Gonzaga. And based on the recommendations of the Office of the Court Administrator, we amended House Bill number 3091 and increased the proposal from 6 to 9 additional branches of the RTC in Davao del Norte and Compostela Valley. We also have House Bill number 3263, authored by this representation, which seeks to create 1 additional RTC branch based in Villaba, Leyte. We also have House Bill number 3628, authored by Honorable Representative Abraham Bambol Tolentino, creating 1 additional branch of the RTC in the municipality of Alfonso in Cavite. We have House Bill number 4265, authored by Honorable Representative Juliet Uy, creating 1 additional RTC branch in the municipality of Villanueva in Misamis Oriental. And House Bill number 4308, authored by Honorable Representative Helen Tan, which was also amended by the committee upon the recommendation of the Office of the Court Administrator to create 4 additional RTC branches instead of 1 in the municipality of Calawag, Quezon Province. After the approval of the committee reports on the said bills, the committee will forward the reports to the Committee on Appropriation for its comments as required by the rules. The next item in our agenda is the initial consideration by the committee of additional bills, creating also new courts, salas. These bills are House Bill number 376, filed by Honorable Representative Eric Olivares. House Bill number 393, filed by Honorable Representative Luis John Ferrer, the fourth. House Bill number 572, filed by Honorable Representative Greg Gasataya. House Bill number 628, filed by Honorable Representative Joel Mayo Z. Almario. House Bill number 724, 4190, and 4714, filed by Honorable Representative Lucy Torres Gomez. House Bill number 727, filed by Honorable Representative Romeo Halosos Jr. House Bill number 1816, filed by Honorable Representative Rogelio Pacquiao. House Bill number 2005, filed by Honorable Representative Alfred Vargas. House Bill number 2243, filed by Honorable Representative Alan Aldu Duhali. And House Bill number 2286, filed by Honorable Representatives Muhammad Khalid Dimapuro and Abdullah Dimapuro. We shall first hear the authors or any duly authorized members to sponsor the respective bills. If the author of the bill or any member duly authorized by him or her is not present to sponsor the bill, we shall defer consideration thereof. After sponsorship, we will hear the recommendations of our resource persons from the Office of the Court Administrator, the DOJ, the DBM, the PAO, the IBP, and the committee may then amend or approve these bills. Third in the agenda will be the continuation of the deliberations on House Bill number 4553, filed by this representation, which seeks to amend Article 70 of the revised Penal Code that puts a limit of 40 years as the maximum period for which a person may be imprisoned. As I earlier mentioned, during the initial deliberations of this bill, I filed this bill in order to remove the apparent disparity in the punishment of a person who was convicted of a single count of reclusion perpetua versus a person who was convicted of multiple counts of afflicted penalties. One famous example is the case of former Mayor Antonio Sanchez, who was sentenced to 7 counts of reclusion perpetua for the rape and murder of students, Eileen Sarmenta and Alan Gomez, plus 2 other counts of reclusion perpetua for murder. Sentenced to a total of 9 counts of reclusion perpetua, Mr. Sanchez may be released after serving only 40 years based on Article 70 of the revised Penal Code. This, to my mind, defeats the purpose of sentencing an accused to multiple counts of reclusion perpetua due to the gravity and depravity of the crimes committed. Obviously, a person who commits 9 acts of murder is more depraved than a person who committed just 1 murder. But it is the height of injustice when both persons may be released after serving only 40 years in prison. We seek to address this by deleting the paragraph in Article 70 that sets the cap of 40 years, thereby letting the person fully serve his or her sentence as imposed by the courts. During the previous meeting, we asked the DOJ, the PAO, the OCA, the Bucor, and the IBP to give their respective position papers on this bill. We will be hearing from them later. Finally, the last topic in our agenda involves various bills also amending the revised Penal Code. This time with respect to the granting of good conduct time allowance, or GCTA, to persons deprived of liberty, or as we call them, PDLs. This topic has been thoroughly discussed by our counterpart committee in the Senate, chaired by Honorable Senator Richard Gordon, but we shall no longer dwell on the issues that were brought up before the Senate investigation. We are here now to take concrete steps in ensuring that the mess created by unscrupulous individuals in taking advantage of the law will no longer be repeated. For the information of the body, the Chair immediately filed House Bill number 4628 to rationalize the grant of GCTA after the briefing conducted by the DOJ and the Bucor during our organizational meeting last September. Under my proposal, Article 29 of the revised Penal Code will further be amended to clearly disqualify escapees, recidivists, and habitual delinquents from deducting their preventive imprisonment to their final sentence, and to remove any ambiguity under the previous amendment that affected the grant of GCTA to persons convicted of heinous offenses. Just to remind my colleagues and everyone here, the grant of GTA has been expressly allowed by the revised Penal Code since its inception in 1939, without distinction as to the crime committed. Unfortunately, Republic Act 10592 increased tremendously the amount of time that may be deducted from a convict's sentence, which led to the grant en masse of GCTA, with several allegations of Bucor officials selling GCTA to the highest bidders. In my bill, I propose to rationalize the number of days per month that would be deducted for good conduct, not too far from the original provision in the revised Penal Code. Finally, I also propose to give the power to grant GCTA to the court that rendered judgment in the criminal case of the PDL. GCTA being an integral part of satisfaction of judgment, and satisfaction of judgment being the end line of the jurisdiction of courts. This is to ensure that the grant of GCTA will not be subject to the whims and caprices of correction officers, for the court to conduct hearings and to inform the private offended parties and their families when it deems necessary. I understand that there are several bills proposing similar amendments to the revised Penal Code provisions on GCTA, but with certain differences as to the specific amendments. The Secretariat has already distributed copies of the matrix showing the differences among these bills, and we have also invited our usual resource persons from the DOJ, the OCA, the PAO, the National Prosecution Service, the PNP, the Bucor, the BJMP, and the IBP to give their thoughts on the various proposals before us today. I hope that we will have a very fruitful discussion on the various topics today. Thank you, ladies and gentlemen. At this point, I would like to acknowledge the presence of the following regular and ex officio members of the committee, as well as other members who are authors, sponsors of the bills before us. Will the committee secretary please read them?
Thank you, Your Honor. Good morning. The committee acknowledges the presence of the following members and authors present today: the Honorable Vice Chairperson Juan Fidel Felipe Nograles, the Honorable Vice Chairperson Alfredo Gorbin, Honorable Representatives Ruel Peter Gonzaga, Aleta Suarez, the Honorable Deputy Speaker Rodante Marcoleta, the Honorable Representatives Alan Duhali, Luis John Ferrer, Peter John Calderon, Lawrence Fortun, Arlene Brosas, and the Honorable Deputy Minority Leader Carlos Zarate.
Okay, we now proceed to our meeting proper. First item is the approval of the committee reports on House Bill numbers 842, 1156, 1446, 1619, 2122, 3091, 3263, 3628, 4265, and 4308. As I earlier mentioned, these bills were already approved by the committee in the previous meeting, and the corresponding committee reports are before us for approval. The floor is now open for any motion on the matter.
Mr. Chair, I would like to make a manifestation.
Yes, Honorable Duhali.
Mr. Chair, the committee report on House Bill number 3091 is under consideration today for approval. The bill co-authored by former Speaker Pantaleon Alvarez, Representative Roel Peter Gonzaga, and this representation was approved during the last meeting of the committee, and its purposes the creation of 9 additional branches of the Regional Trial Court in the 11th Judicial Region, including the creation of 1 additional RTC branch in the island garden city of Samal. I have also filed a similar bill, which is also under consideration today, House Bill number 2243, which proposes the creation of 1 additional RTC branch in the island garden city of Samal, as well as another RTC branch in the city of Panabo, Davao del Norte. Considering the House Bill number 3091 was already approved by the committee with amendments, I would like to propose another amendment to House Bill number 3091 by way of consolidation with House Bill number 2243 to include the creation of 1 additional RTC branch in the city of Panabo, Davao del Norte, thereby increasing the number of new RTC branches in the 11th Judicial Region to 10. I so move, Mr. Chair.
There is a motion to consolidate House Bill number 2243 with House Bill number 3091, adding the creation of 1 branch of the Regional Trial Court to be stationed in the city of Panabo, province of Davao del Norte. Do I hear any objection? There being none, the motion is approved.
Mr. Chair, I move to approve the committee reports on House Bills 842, 1156, 1446, 1619, 2122, 3091 as amended, 3263, 3628, 4265, and 4308. So moved, Mr. Chair.
Is there any objection? There being none, the committee reports on House Bill numbers 842, 1156, 1446, 1619, 2122, 3091, 3263, 3628, 4265, and 4308 are hereby approved. We go to the initial consideration of bills creating court salas. This is the next item on our agenda. Initial consideration of bills creating additional salas. First bill is House Bill number 376 of Honorable Representative Eric Olivares, who is now recognized to give his sponsorship speech.
Mr. Chair, on behalf of Representative Eric Olivares, I move to sponsor House Bill number 376 and move to adopt the explanatory note thereof as sponsorship speech in the said bill. So moved, Mr. Chairman.
I see no objection. The same is approved. We now go to Honorable Representative Luis John Ferrer for his sponsorship speech on House Bill number 393.
Thank you, Mr. Chair. Can you please accept the explanatory note on our bill as my sponsorship bill speech, Mr. Chair?
Okay. Next to be recognized is the Honorable Representative Greg Gasataya for his sponsorship speech for House Bill number 572. The matter is therefore deferred to another meeting. Next is the Honorable Representative Joel Mayo Almario for a sponsorship speech on House Bill number 628.
Mr. Chair, I was requested by the Honorable Representative Joel Mayo Almario to sponsor House Bill number 628. I therefore respectfully move that explanatory notes of the House Bill number 628 be adopted as the sponsorship speech.
Thank you. We proceed with the sponsorship speech of the Honorable Representative Lucy Torres Gomez for House Bills numbers 724, 4190, and 4714.
Mr. Chair, I'm happy to sponsor for and behalf of Congresswoman Lucy Torres, creating various additional courts in the province of Leyte. And I move that the explanatory note be adopted as the sponsorship speech. So move, Mr. Chair.
Approved. We now go to the Honorable Romeo Halosos Jr. for his sponsorship speech on House Bill number 727.
Mr. Chair, I was requested by the Honorable Representative Romeo Halosos Jr. to sponsor House Bill number 727. I therefore respectfully move that the explanatory notes of the House Bill 727 be adopted as the sponsorship speech.
Chair, Mr. Chair, may I know
yes,
the reason
Honorable
why
Marcoleta.
the principal authors of these bills are not prepared to sponsor their own bills, and other members of Congress are the ones.
Committee
speaking for-
Secretary.
Good morning, Your Honor. Your Honor, the Honorable Representatives Olivares, Gasataya, Almario, Gomez, Halosos, Pacquiao, and Vargas and Dimaporo informed the Secretariat that they will not be they will be unable to attend the meeting due to other committee meetings that they are also attending, Your Honor.
Due to other committees they are attending at present. May we know whether or not these committees are more important than the bills which are being presented today? Just for curiosity, Mr. Chair.
It is not
Because
for
I
the-
believe these are very important pieces of legislation. If not for their importance, they would not have filed them in the first place. And so, just for purposes of ascertaining the other important measures that they have been attending in other. I am not, of course, objecting, Mr. Chair, but I'd like to know how much importance they have attached to their own bills, why they cannot be present today.
It is good to note that the Honorable Marcoleta is not objecting, and it is not for the chair to explain why the sponsors are not around. Thank you, Honorable Marcoleta. We now proceed. Saan ba tayo? To-
Pacquiao na po, 1816, pero pinadefer na rin. Huwag na yan. Pinadefer na po yan. Vargas.
We now proceed with the sponsorship speech of the Honorable Representative Alfred Vargas on House Bill number 2005.
Mr. Chair, in behalf of Representative Alfred Vargas, I move that the explanatory note be adopted as his sponsorship speech. As a consequence, Mr. Chair, I move for the adoption of House Bill number 2005. So move, Mr. Chair.
We now proceed with the sponsorship speech of Honorable Representatives Muhammad Khalid Dimapuro and Abdullah D. Dimapuro on House Bill 2286.
Mr. Chair, upon the request of Congressman Dimapuro, both Khalid and Abdullah, I'm happy to sponsor for and behalf of the two congressmen an act transferring the seats of the two branches of the Regional Trial Court in the province of Lanao del Norte to be stationed at the municipality of Tubod and creating two additional branches of the Regional Trial Court in the province of Lanao del Norte. Further, Mr. Chair, I move that the explanatory note be adopted as the sponsorship speech. So moved, Mr. Chair.
No, there being no objection, the same is granted. Uh, Sino pa?
And for Congressman Greg Gasataya, Mr. Chair, for and in his behalf, I'm also sponsoring an act creating two additional branches of the municipal trial courts in the city of Bacolod. And the sponsorship speech, Your Honor, or the explanatory note shall be part of his sponsorship speech.
On
So
House
moved.
Bill number.
On House Bill 572.
Thank you. Thank you, distinguished sponsors of the bills. We now recognize our resource persons for their comments and inputs on the various bills justice sponsored. May we call on, well, we will be calling on the resource persons representing the Office of the Court Administrator, DOJ, DBM, POW, and IBP in that order. Office of the Court Administrator, please.
Good morning, Your Honors, and everyone present in this committee hearing. Regarding House Bill number 376, which proposes the creation of two additional branches of the Metropolitan Trial Court in the city of Parañaque. Based on studies, the manageable caseload of first-level court is 500. And there are 7 existing METIC branches in the city of Parañaque with a combined caseload of 1,631 as of September 2019. The average caseload is 233 per branch, while the average caseload per branch of 233 is considered manageable, considering that the city of Parañaque is a first-class, highly urbanized city in Metro Manila, with a population of 655,822, we favorably endorse the bill, but propose the creation of 3, not 2 additional branches.
DOJ. So, are you saying, Your Honor, that you are recommending approval on all the bills?
Yes, with additional one more, Stella.
For,
The House Bill number 376,
you need additional
one more sala
one more sala.
in Parañaque, METIC Parañaque.
That will have to be covered by the sponsor is here around. Okay. This would need an amendment, therefore. How about, ididiretso ko na ito, no? About 393.
With regards to House Bill number 393, RTC Branch 23, Branches 130 and 131, and Branch 5 FC for Tres Martires City are under the jurisdiction of Tres Martires City and have jurisdiction also over the municipalities of General Trias and Tanza. At present, there are 3 RTC branches in Tres Martires City, Branch 23, and 2 newly created courts, Branches 130 and 131, created under RA number 10454, which are already organized. There is also one newly created Family Court, Branch 5 FC, Trece Martires City, created under RA 8369, or the Family Courts Act of 1997, which is already organized and exclusively handles child and family cases. Branch 23 RTC Trece Martires City has a total caseload of 4,207 as of May 2019. The caseload alone reveals a very blatant reality that this court is overburdened. Although there are two newly created courts, the number of the RTCs are still not sufficient. The ideal number of courts in the station should be 12 RTC branches to achieve an average caseload of 350 per month. It is noted that the city of General Trias is a first-class component city with a population of 314,303. With the rapid growth in urbanization and infrastructure development, increase in the filing of cases is inevitable. In fact, the lone empty municipal trial court in the city of General Trias has a total caseload of 403 as of August 2019. Thus, the office endorses the creation of 2 additional RTC branches to be stationed in the city of General Trias, Cavite.
How many RTCs do you need?
Two more.
2 more. Again, this will be covered by necessary amendment. How about House Bill 572?
Regarding House Bill 572, the 7 existing branches of the MTCC Bacolod City, Negros Occidental have a combined caseload of 1,326 as of September 2019. The average caseload is 189 per branch. Although the MTCC Bacolod City sustains a manageable caseload, Bacolod City is the capital of the province of Negros Occidental and is a first-class city with a population of 561,875, the most populous city in Western Visayas. Thus, the office supports the proposed bill, the creation of 2 MTCC in Bacolod City.
So
We
this is
support.
just okay.
Yes.
Okay, thank you. We go to House Bill 628.
There are 2 existing RTC branches, Branch 5 and 6, City of Mati, Davao Oriental, who take cognizance of cases arising from the municipalities of Caraga, Manay, Mati, and Tarragona. There is also one newly created family court, Branch 8 FC in Mati City, Davao Oriental, created under RA 8369, or the Family Courts Act of 1997, which is still unorganized. The 2 RTCs have a combined caseload of 731 as of September 2019. The average caseload is 366. Although the average caseload is only a bit beyond the manageable level of 300, however, Mati City is the capital of the province of Davao Oriental, with a growing population of 141,141. Thus, this office supports the proposed House bill for the creation of 2 additional RTCs in the Mati, Davao Oriental. And the proposed creation of 2 additional MTCCs in the city of Mati City. The lone MTCC, City of Mati, has a caseload of 200 as of September 2019, and the existing court is still sufficient for the purpose. However, this office also endorses the proposed House bill based on the number of population and it being the capital of the province. So we support the bill.
No additional sala needed.
No more.
Thank you.
regarding House Bill 724 that proposes the creation of one additional branch of the MTCC in the city or Ormoc province of Leyte. Ormoc City is a first-class city in the province of Leyte with a population of 251,031 and is considered the largest city in Leyte. The lone MTCC or Ormoc City Leyte has a total caseload of 731 as of September 2019, which exceeds the identified manageable caseload of 500. To achieve our advocacy to help decongest the court, the office endorses the proposed creation of two, not one, additional branch for the municipal trial court in cities in the city of Ormoc, making a total of 3 MTCCs in the place. So we propose additional one more courts. Instead of two,
So
instead of
you're amenable to 3, 2, or just 1?
two, only two, instead of one.
So for Ormoc, no?
And for Ormoc MTCC.
Okay. Okay.
For House Bill number 727, the Pitan City is a third-class city in the province of Zamboanga del Norte with 82,418 inhabitants and a tourist attraction in Zamboanga del Norte. It is noted that despite the growing population of the city of Dapitan, it has no regular trial court. However, there is one newly created family court, branch 4FC, Dapitan City, Zamboanga del Norte, created under the Family Courts Act of 1997, which is still unorganized. It is also noted that the lone MTCC Dapitan City has a caseload of 949 as of September 2019, which is beyond the manageable caseload. It's beyond the manageable caseload. This office appreciates and supports the creation of 2 RTCs in the Pitan City, but not the family court, since there is already one family court created under RA 8369, which is still unorganized. So instead, we don't need to create a family court.
So what you're saying is you disagree with the desired creation of one family court,
Yes,
but you agree to the creation of
Of
2
two
more
RTC.
branches of RTC.
yes.
Thank you.
Regarding House Bill number 1816,
Mr. Chair, may I ask Attorney Ching if it is more preferable to the Supreme Court to adopt a system where, let's say, each legislator, if you can inform or appraise the committee, for example, of the most clogged dockets courts in the country, so that each and every legislator will be able to respond more effectively. Because what I can see is that the cart is being placed before the horse. So parang ano kami na ito kailangan ito, pero pagdating pala sa mas kailangan tong ganun. For example, in Rizal, kung alam po namin siguro yung most clogged docket siguro, no? Kasi the trial courts in Antipolo, for example, hindi ko alam kung mga 6 o 8 RTCs na yan. No? Sometimes the trial courts of Taytay are also assisting. There were certain periods where even the trial courts as far as Morong are assisting the RTCs of Antipolo. So if the Supreme Court periodically informs the Justice Committee, for example, of the conditions of the courts, then I think the members of this committee, more specifically the concerned members of the House, will be able to respond more effectively. Hindi yung parang tsambahan lang. Meron naman tumatama, meron namang, di ba, nag-a-adjust tayo. Thank you, Mr. Chair.
Attorney Ching. Response to the observation of the Honorable Marcoleta.
Your Honor, we will submit periodical information regarding the clock dockets in the country. Yes. Before we're doing that, pero we stopped it before. I think mga 5 years ago. We did it because somebody requested for it. Pero, but in our office, we have a list of
Will the Honorable Marcoleta please put on his mic?
Thank you, Mr. Chair. May I know why did you stop doing it? I think this is a very good
Pero in
mechanism because each one will be able to know each other's needs. Diba? We can help you better by knowing your needs. And then walang tsambahan, talagang specific, targeted areas where RTCs or MTCs, MTCCs can be created at the right time and at the right place. So, siguro, Mr. Chair, we can continue to adopt a system where each institution is well informed of each other's needs. Thank you, Mr. Chair.
Your Honor, in our office, we have the data for the clock dockets because the JBC now are considering the opening of those with clock dockets. Before, they are doing it by region, now based on caseloads.
Attorney Ching, we have a new law creating judges at large.
Yes.
Will that be of any help? Declogging heavily clogged salas.
I'll be speaking based on my personal opinion because I think the judges at large can help because instead of taking a judge with regular sala to preside in another sala in addition to his regular sala, his performance in his regular sala will be affected. Whereas if we have judges as large, those judges as large will be assigned in those branches which was vacated due to whatever reason, kung death or retirement. So we will have an judges who can fill in the vacancies, not get a judge with a sala and give him or her additional load.
Has that law been implemented already? Not yet.
Not yet po.
Why?
Is it already approved?
I heard it was already approved by the President.
Pero we have not received, and I think there should be guidelines. Once it's approved, there must be guidelines how to implement it.
Another point, Attorney Ching. I noticed in relation to House Bill 727, you said that there is no need for the creation of a one-family court, but there is a need for the creation of 2 regional trial courts. As you know, Congress versus the Supreme Court, when it comes to jurisdictional matters, it is for Congress to pass the necessary laws. But when it comes to procedure, it is for the Supreme Court to craft the rules, be it in the rules of court or be it in a matter of administrative matter. Family courts are of limited jurisdiction, is that correct?
Yes, child
They-
and family cases.
Being created only for a specific jurisdiction enumerated in the law creating a family court, it cannot exercise jurisdiction over regular RTC cases.
But at present, our practice is we also, if the judge appointed in a family court has no court yet, has no house yet, and personnel, so that they can exercise their duties and they are receiving their salary, we are designating them either as assisting judge. If there is a family court, a vacant family court in a family court, but if there's none, they are also designated as acting or assisting judge in a regular court.
Yes, that's precisely my predicate. My premise was matters of jurisdiction are within the confines of Congress. Matters of procedure are exclusively the concern of the Supreme Court under Article 8 of the Constitution. So, the Supreme Court can assign one family court judge to act as RTC judge in an RTC sala that requires the services of a presiding judge. The Supreme Court can do that. But she cannot actually exercise jurisdiction over matters that are exclusively within the exclusive jurisdiction of family courts, assuming one is raised in an RTC case.
Since the creation of statutory family courts is based on the law, and we have other courts designated to preside over, to be family courts. Aside from those statutory family courts, we have several designated family courts because the statutory family court which provides are not enough to handle the child and family cases in a certain area. So, although we have appointed the first strands of the statutory family courts, we did not revoke the designation of those regular judges which were designated as family courts.
The reason I'm asking that is that way back 1970s, there was a domestic family court in Quezon City. The case was actually cognizable by an RTC, CFI then at that time. I succeeded in having that case dismissed on the premise that the law creating that court came up with a limited enumeration of jurisdiction cognizable by the domestic family court, juvenile, it was domestic, juvenile, domestic court, something like that. So that just as an MTC judge cannot be designated to perform functions of an RTC judge, it can be argued. I am not saying that that is my position now. Just as an MTC judge cannot be designated as an RTC judge, in the light of the fact that the appointment limited his function only to that of being an MTC judge, an RTC judge cannot also be designated to function as an MTC judge. How about family courts?
That was the reason why whenever there's a case pending in the first level court involving minors, those cases are transferred to the family court, the designated family courts.
Anyway, that would be a good subject for another meeting. We now go
Yeah,
to
Mr. Chair, corollary to the clogged dockets, which being experienced not just in one region but in the entire country. Normally, this is being a product of those salas that were vacated due to retirement or resignation or death of a particular judge. But based on experience, as used to be a practitioner for 6 years, ang tagal ho ma-open yung sala, yung vacancy. Like for example, in RTC Legazpi, 6 RTCs, bago ma-filled up, took almost 4 years. Ngayon, meron pang 3 open na bakanteng RTC sa Legazpi. Magdadalawang taon na, hindi pa rin na-fill up. Hindi pa rin open. Bakit ho ganun yung proseso ng why? Yes. What I'm saying is
Baka inuuna yung kitchen.
ikaw naman akala ko sasabihin. So, I think this is the primary factor why one, we have a clogged dockets. The natural course is that whenever there is a vacant sala, the same will be pinapatong sa yes,
It's
pairing.
either the pairing court.
Pairing
or
court,
if not
oo.
available, we get.
Ang daming mga West sa Bicol na were assigned as a pairing judge we have 2 island provinces. Pag ina-assign na sila doon, tumatawag na sa akin.
Yes.
Kung tawagan mo na, patulong naman ako, wag ako i-assign doon sa. So, those are bakit hindi ho natin immediately open yung sala at ang daming gusto mag-apply ng West.
I think the JBC people are the proper person to answer for that. I'm
Is it
not
the JBC or the Supreme Court?
the JBC, because they have procedures to follow, and I'm not familiar how they prioritize the opening, except that I know now that they are prioritizing those salas with clogged dockets, with heavy caseload.
Yeah. Another thing is, because I'm intimating on filing a bill with regard to this one, Mr. Chair, so as to address clogged dockets. On specialization of courts on particular cases, we have family courts,
Drugs court,
Drug court.
commercial courts.
yes. Why don't we specialize everything na lang? Criminal courts, civil courts, so that they're just getting your opinion on the matter. Pag ang isang OS nakatutok lang sa isang subject matter like all criminal cases, hindi sabog-sabog yung kanyang, with just the browse of the records, including that of the cases pending before his or her sala, meron siyang expertise. Did the Supreme Court ever made a study on specializing all courts, whether it's RTCs or MTCs?
As a rule, all RTCs are courts of records, and that's the reason why from there, we designated some of them as family courts, drugs court, commercial courts. So I think the court is doing its job and the Philippine Judicial Academy, the PILJA, is training our judges in different aspects of law so that they can handle the cases properly. And that's why sa drugs court, before, we have only designated drugs court to handle drugs cases. However, around 4 years ago, the then Chief Justice, the lady one, Sereno, the court issued a resolution, parang all the RTC courts can handle drugs cases. So practically almost all regular courts are handling drugs cases now because of the influx of the filing of drugs cases.
Okay. Thank you, Mr. Chair.
Kindly, for the guidance of the committee, Attorney Ching, kindly submit to the committee a list of those who were already shortlisted by the JBC for appointment by the President, and another, those salas which were already filled up by appointments issued by the Office of the President, but which are not as yet functional. Because I heard that there are salas filled up but could not function for one reason or another. One is walang building, there are a lot of reasons. And kindly, well, even only on those 2 points, kindly submit to the committee a list of, again, salas that were already covered by shortlisting from the JBC, and another salas, newly created salas that have been filled up by appointments issued by the Office of the President, except that they are not functional yet. Is that okay?
Yes.
Thank you.
Your Honor.
We now go to okay. The chair acknowledges the appearance, the attendance of the Honorable Representative Nina Taduran. We now go to House Bill number 2005, authored by the Honorable Representative Alfred Vargas. Attorney Ching.
At present, there are 48 existing RTC branches in Quezon City and 20 newly created branches 302 to 320, created under RA 10704, which are still unorganized. There is also one newly created family court, branch 13 FC NCJR Quezon City, created under RA 8369, which is already organized. The combined caseload of the 48 existing branches is 20,225, with an average caseload of 421 per branch. With the creation of the 20 more RTC branches in Quezon City, the average caseload, when organized, will be greatly reduced to 297 per branch. Considering that there is no RTC branch yet in Novaliches, the proposed House Bill is endorsed. And the proposed creation of additional branch in the Metropolitan Trial Court in the NCJR to be stationed in Novaliches, there are already 18 existing METICs in Quezon City and 22 newly created branches, METICs branches 131 to 152, created under RA number 10480, of which 10 courts are organized and 12 courts are still unorganized. The combined caseload of the existing METICs is 9,981 as of September 2019, with an average caseload of 554 per branch. Thus, the office supports the creation of one additional METIC branch with seat at Novaliches.
Attorney Ching, a while ago I was asking you about list. How do you differentiate organized from unorganized courts?
The organized courts are those with appointed judges. Those unorganized courts with no judges yet, although the bills had been approved, but no judges had been appointed by the president. It's either the JBC have submitted the list, or they're still under study, under consideration for possible qualified applicants?
So the list that I was asking a while ago covers unorganized
Yes,
courts.
yes.
And the organized
Organized
courts are
courts.
those that are already functional,
Yeah.
not
And,
necessarily.
there are judges appointed, but they cannot function yet in their regular station because at present they have no personnel yet, and there is no courtroom where they can hold office and court session. That's the reason why we are designating them either in an acting or assisting capacity in other courts, either within the region or outside of the region where they were appointed.
So for clarity, let me just have that list distinguishing organized from unorganized, and kindly inform the committee why organized courts are not functioning yet. And on the matter of unorganized courts, kindly inform the committee where the bottleneck is. Is it because the JBC has not shortlisted yet the applicants, or is it because they have already submitted the shortlists, but the Office of the President has not issued appointments yet?
Yes, there are
Okay.
cases like that.
Thank you. We now go to House Bill 2286.
For House Bill number 2286, proposes the creation of 2 additional branches of the RTC to be stationed in Tubod and Kapatagan, both in the province of Lanao del Norte, and transferring the seats of 2 branches of the RTCs with seats at Iligan City. Section 1 of the bill, of the House Bill 2286, states that 2 existing regional trial court branches with seat at Iligan shall be transferred to the municipality of Tubod and Kapatagan. We have no objection to the proposed transfer of the 2 branches to the municipality of Tubod and Kapatagan, Lanao del Norte. Our only quandary is which branch in Iligan are we going to transfer to Tubod or Kapatagan? Because they're already existing.
Can that be answered by whoever is representing the Honorable Khalid, the father and son, Dimaporos? Wala rito, no? Okay, we defer action on that in the light of the query of Attorney Ching. Any comment from the DOJ?
Good morning, Mr. Chair, and all the members of the committee. The DOJ, we reiterate our position since we are also part of the agencies who are faced with the clogged dockets. We believe that the solution to this problem starts with the creation of the courts. And we are in full support of the creation of this courts and the passage of these bills into law. Thank you, Mr. Chair.
Thank you, Attorney Aguilar. On the part of the DBM, any comment? Thank you.
Sir, good morning. Regarding the creation of additional court, may we highlight that the DBM and the Supreme Court have already established a standard staffing pattern regarding the creation of positions. So once the law is passed and it is submitted to DBM, we just documented whatever is the proposal. Thank you, Mr. Chair.
Thank you. From the PAO?
Well, Your Honor, good morning. We join the DOJ in the rationalization that we support the approval of these bills provided that we are given additional budget in also installing one public attorney per sala created.
Well taken. Any representative from the IPP? I think there's none. So, having heard the comments and recommendations of the resource persons invited, is there any motion?
Yeah, Mr. Chair, based on the recommendations of the resource persons, I move to amend House Bill 376 to create 3 additional metropolitan trial courts in the city of Parañaque. And I also move, or shall we dispose of the, or I also move for the consolidation of House Bills number 724, 4190, and 4714, authored by Representative Lucy Torres. So move, Mr. Chair.
Any objection? There being none, same is approved. From the chair, before that, by the way, is there any motion to amend House Bill 393 in the light of the observation of Attorney Ching? Walang dalawa pong, sabi niya, dalawa pang kailangan eh. 2 more, right?
Mr. Chair. Mr. Chair.
Okay. Okay. Yes, Honor.
Yeah. And with the explanation of Attorney Ching, I can amend my bill. Ma'am, is it okay to add additional, instead of 2, to make it at least 3 additional RTC courts in General Trias, ma'am? Kasi as of your records po, we have 4,000 pending cases in 13 Martires courts. 70% of which comes from General Trias City. As per my records, ma'am. So,
At present, there are already 3 RTC branches and 2 newly created courts, 130 and 131. Na-organized na po yun. And then, there's another one coming to be there's another one FC, family court. So the other cases involving child and family will be transferred to the family court. Although the ideal, based on the number of caseload, parang the ideal should be 12 talaga, to have an average of 350 per branch. Pero with our continuous trial and the civil cases will have also continuous trial, siguro if the judges are industrious enough, they can handle these cases.
So can we have 3 instead of 2?
Sige po, pwede naman kasi actually the caseload magiging 403 noon maski ma-open yung iba. I think we can add 1 more. Instead of 2, it's 3.
Okay. So is there any objection to the motion of Honorable Representative Ferrer? There being none, so the motion to amend is approved.
thank you, Mr. Chair.
Any motion for the omnibus approval?
Mr. Chairman, I move to approve House Bill number 376 as amended, 393 as amended, 572, 628, 724, 4190, 4714 as amended, 727 as amended, 2005, subject to style. So moved, Mr. Chairman.
Second.
It having been moved and seconded, the same is approved. Subject to style, the committee secretary is hereby directed to draft the committee reports and the corresponding substitute bills for the approval of the committee at the next meeting. Yes, Your Honor. Kumzarati.
Members present as co-authors of the subject bills. Thank you, Mr. Chair.
So all members present are co-authors, will be co-authors of the subject bills. We go to continuation of deliberations on House Bill number 4553. Last meeting, we asked DOJ, the PAO, the OCA, the Bucor, and the IBP to submit their respective position papers. Have they complied with the, I don't call that directive to the request.
Your Honor, for House Bill 4553, the Office of the Court Administrator is so grateful for considering our position on the matter. However, the office cannot give its official comment and or recommendation on House Bill 4553 so as not to preempt any legal opinion the Supreme Court may render if the bill is approved and later questioned before the Supreme Court.
Okay, PAO is not around. How about the, okay, sorry. IBP pa lang wala. PAO.
Good morning, Mr. Chair. The Public Attorney's Office has already submitted its position paper on House Bill 4553 last October 7.
Okay, so
Mr. Chair,
Honorable Fortune.
may we know the position of the Public Attorney's Office? Thank you, Mr. Chair.
The Public Attorney's Office supports House Bill number 4553, proposing the repeal of the 5th paragraph of Article 7 of the revised Penal Code. This office is of the opinion that the repeal of the aforesaid paragraph will remedy the existing inequality between those who were sentenced to suffer 1 reclusion perpetua and those who were sentenced with multiple counts thereof. The moral depravity of those sentenced to suffer multiple penalties justifies the removal of the limit imposed by Article 70. After all, in the 1987 Philippine Constitution, it is explicit that under Section 1, under Article 3, that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Thank you, sir.
Fortune, does that satisfy you?
At least I know the position, Mr. Chair, but I'm not very satisfied.
Okay, thank you. How about OCA?
Is it House Bill 4553?
455. At tapos na siya. The DOJ has not given a, siya nang tapos na eh.
OCA po yung natapos. DOJ hindi pa nagsasalita.
Nasaan bang OCA?
Siya yung OCA.
Nakalagay kasi Supreme Court eh. Okay, DOJ.
Again, good morning, Mr. Chair. The DOJ, I think, has submitted its position because we have a copy of the position paper signed by the Undersecretary in charge, dated 9 of October 2019. Thank you, Mr. Chair.
Mr. Chair, can the DOJ articulate their position on the matter?
DOJ?
Thank you, sir. Considering the importance and gravity of this piece of legislation, We would like to inform this body that the State Council assigned to review and study this case is currently on official leave, and we cannot speak in her behalf because we are representatives here for other bills, Mr. Chair.
What is the position of the DOJ? Are you asking for more time to articulate?
This-
So you have reservations on this bill,
I believe so, Mr. Chair, but
grounded on what?
these representations here present today are not in a position to articulate our position since we are not the officially authorized to speak in behalf of the department.
So in effect, you are not objecting.
Yes, Mr. Chair, we are not objecting.
Okay. How about Bucor?
Your Honor, on the part of the Bureau of Corrections, we seek the indulgence of the Honorable Committee to grant us more time to formulate our position paper, considering the fact that most of our key officials were suspended and there's only one lawyer assigned at the legal office as of the moment, Your Honor.
Oh my God, you cannot put us on suspended animation for a long time. So how many days would you need?
Within the weeks, Your Honor.
5 days, 3 days, 7 days? 3 days is within the week, 5 days is within the week, 7 days is within the week. Which of the three?
5 days, Your Honor.
5 days.
Yes, Your Honor.
Thank you. BJMP.
Good morning, Mr. Chair, Your Honor. I think, sir, the BJMP is not concerned about this proposed bill. We are for the GCTA bill, sir.
Okay. So going back to Bucor, if BJMP is not concerned about this because they are plain custodians, how about Bucor?
Sir, same with the BGMP. We were invited here with respect to the bills being filed with respects to GCTA, Your Honor.
Not in relation to Article 70.
No, Your Honor, with respect to GCTA, Your Honor.
Clarification from the chair. As earlier mentioned, Article 3, Section 1 says, no person shall be deprived of his life, liberty, or property without due process of law, nor shall anybody be denied equal protection of the laws. In a nutshell, Article 70 denies equal protection of the laws to a convict of 1 reclusion perpetua. He is being put at par with a convict of 9 reclusion perpetua. Because Article 70 says, despite, this is how the revised penal code treats it. Okay? First, ilang taon ba talaga ang reclusion perpetua? Is it 30? Is it 40? Now, ang reclusion perpetua mo, subject to the threefold rule. Threefold rule, meaning, if it is 40 years, dapat 120. But in Article 70, it says, hindi pwede lumampas ng 40 ang service of sentence mo. So, in class, to drive home a point, we come up with the most exaggerated example, except that current events show that these are no longer exaggerated examples. In the case of Sanchez, 9 reclusion perpetua. Biro mo, hanggang 40 years lang siya. Yung isa, murder, reclusion perpetua, hanggang 40 years din siya. Kasi mga threefold rule eh. I will drive home a more, we call it now classical example. Kasi ang dami ng mga durugista ngayon. At the age of 18, merong serial rapist. Nire-rape na pinapatay. Palagay mo na lang, in span of 1 year, 50 ang na-rape niya at pinatay niya. 18 plus 40, he will only be 58. Pakakawalan mo siya at the age of 58. Paglabas niya, kung sinunod yung sinasabi ng mga napuntahan kong mga, kasi nagiging speaker din ako sa mga drug rehab noon, yung charismatic namin. Once an addict daw, always an addict. I don't know how true that is. Paglabas niya, at the age of 58, balik siya sa dating ugali. Mangre-rape na naman, papatay na naman. Simply because Article 70 says that hanggang 40 years lang ang incarceration niya. I am not saying that we should do away with the threefold rule. I am only saying na, for Diyos, tanggalin mo naman yung 40 na limit. Okay? That is the thrust of Article 70. So, siguro in 5 days, maliliwanagan tayo ni Attorney Lawagan. Okay? Parang magkapareho na yung maliliwanagan at lawagan.
Mr. Chair.
Okay. Yes, Attorney Fortune. Your Honor, Representative Fortune. My apologies.
Thank you, Mr. Chair. It appears, Mr. Chair, that the critical agencies that should give comments on this bill has not given their positions as yet. Despite the fact that they have been informed of this weeks ago, I understand that before Congress went into recess, the agencies concerned have been furnished copies already of the bill and were asked for their opinions already. And until now, wala pa pong position. And I do not blame them for that, Mr. Chair. I think they find the matter quite confusing, especially those that have first-hand experience in terms of dealing with convicts, tulad ng Bucor, tulad ng BJMP, at saka ng iba. Tanong ko lang, because so far sa mga agencies na inibita natin, only PAO has given a categorical position already that they are for the bill. May I ask, Pao, nung pong kayo ay nagtatanggol ng mga akusado o kaya convict, pag pinapatawan na ng penalty, pagka lumalagpas po o nagkakamali ang application ng Article 70, siyempre pinagtatanggol nyo, di ba? Ina-assert niyo na hindi po, sobra po yata yan. Hindi yan ayon sa Article 70. So in the course of defending your client, in terms of the appropriate application of Article 70, what's the usual rationale that you give to the court?
Your Honor, good morning. Of course, we apply the law. Okay, if the law says that Article 70 should be applied, and we believe that the threefold rule is still existing right now, so of course we will argue on the basis of the existing law.
Would you know, ma'am, the rationale for Article 70? Because, of course, we already know these concepts of fairness and justice, di ba? That the graver the offense, the graver the penalty, no? The more crimes you commit, more penalties should be imposed. And yet, you have Article 70 that says hanggang 40 years lang ang maximum pagka in-apply ang threefold rule. Pag lumagpas doon, eh hindi na pwede dahil 40 years yung limitation. What do you think is the rationale for Article 70? Why is it in the revised Penal Code in the first place?
I believe it's due to reformation theory.
So in other words, you agree that this Article 70 is actually consistent with the principle that penalties are supposed to be rehabilitative rather than retributive. Is that correct, ma'am?
Yes, and it should also adapt in times. In the science.
And do you think an amendment of Article 70 would be inconsistent already with the principle of rehabilitative justice?
The revised penal code is a legislation, so it is also subject to the pleasure of the current legislative body. If they seem that there's a need to change it, I believe that's also legal in nature.
No question about the legality. We're talking here of the principle of rehabilitative justice. Since you said that Article 70, the rationale of which is actually rehabilitative justice, don't you think that the proposed amendment by our distinguished chair would be inconsistent with the principle of rehabilitative justice? Because that's what the public attorney's office is all about. No? You defend the accused, you defend the convicts, no? And you fight for rehabilitative justice rather than retributive justice.
Well, as for the position of the office that we were given, we believe it is not inconsistent.
Anyway, I will not belabor the issue, Mr. Chair. I'm just trying to get the sense of the public attorney's office. Mr. Chair, I'd like to ask a few more questions sa ibang agencies. I'd like to hear from the DOJ. You said that you are not objecting to the measure. Is that correct?
That's correct, Your Honor.
But a team has been assigned to study the measure. Is that correct? The measure has been assigned or referred to a team or an office under your office for further study. Is that correct?
Yes, Your Honor.
So why are you saying now that you are not objecting when you have not yet completed your review of the measure?
Mr. Chair, I was saying a while ago that this particular bill was assigned to another state council. The copy of the position paper is here with us, and we can only inform the court of the general position of the department, which is not objecting to the passage of the bill, but with reservation. Mr.
Okay. At least that's clear. No? So you're not objecting, but you have certain reservations. Thank you. Would you be at liberty to tell the committee that those reservations?
If I may read, but I cannot further elaborate since I was not the reviewer of this bill. It is mentioned here that instead of the proposed repeal of the sentence on 40 years, referring to the 40 years, this department suggests that Article 70 to be amended by providing for the list of PDLs, persons deprived of liberty, who should not be covered by the threefold rule. To provide for a blanket repeal would deprive other qualified PDLs the opportunity to reintegrate with society as rehabilitated and reformed members of the community. So that's the gist of the position.
Thank you, Mr. Chair. So that's quite different from the position of PAO. Now, PAO is absolutely for the bill. DOJ still wants to sustain the rehabilitative nature of penalties. Okay, I'd like to hear from BJMP. You said that this is not your concern. But isn't it not that decongestion of jails is also part of your concern?
Yes, Your Honor, because the BJMP is, our clients are detention prisoners only, those who are not yet sentenced by the court. That's why, sir, I said that it is not a concern of the BJMP.
Yeah, even then. But of course, you would want jails to be decongested. Is that correct?
Yes, sir. Yes, sir.
So you would want that those inmates, no, who have been found to have been rehabilitated already, would be given the opportunity to reintegrate with society already. You would want that, right?
Of course, sir.
It's rehabilitative justice, and it's also consistent with the objective of the BJMP to decongest our jails, no, para mas madaling i-manage, no.
Yes, Your Honor.
So I suppose that you should at least also give us a position, no, on this bill, pero related doon sa mandate ninyo.
Yes, sir.
I
We will
don't
submit
think
our
it is
position paper.
absolutely not your concern.
Yes, sir.
Tingin ko concern pa rin po ninyo yung ibang aspeto ng measure na ito.
Yes, sir.
So maybe we can ask for your position as well.
Yes, sir, we will submit our position. Sir, we were invited kasi for the GCTA law lang, kaya hindi namin nadala yung position paper.
And finally, Mr. Chair, the Bureau of Corrections, you're the ones who deal directly with the inmates, no? You are the agency that's witnessing firsthand, no, the rehabilitation of certain inmates, no, kung paano sila pwedeng magbago, kung paano yung iba naman hindi na-rehabilitate, no. Hindi natin sinasabi lahat na-rehab, but kayo po yung talagang firsthand na nakikipag-deal sa kanila eh. So I think your position would be very important on this issue. Thank you, Mr. Chairman.
The chair would, first of all, the chair recognizes the attendance of Deputy Speaker, the Honorable Representative Henry O. Aminal, and the Honorable Representative Franz Castro. Question from the chair to Pao. A while ago, you were asked by the Honorable Representative Fortun, what is the rationale for Article 70? While you were mulling the answer, it struck me, kasi I'm already 74 now. I'm pushing rather 74. Representative Fortun, parang pwede na maging anak ko ito eh. In my time, when I was young, I was 18, wala akong naririnig noon na drug addict. Wala akong naririnig noon na mananaksak 30 times, mambabaril 42 shots. Kasi in my time, pag may sinaksak doon, isa patay na. Pangalawa, wala akong naririnig noon na nang-rape, serial rapist, at pinapatay pa. So, in my view, and I would like to get your concurrence or disagreement to this, in my view, okay lang ang 40 years noon. Kasi ang pinag-uusapan noon, nakaw ng kalabaw, nakaw ng manok. In fact, nung 18 years old ako, pagkatapos namin mangharanan noon, kami magpipinsan, may toka, magnanakaw ng manok, sarili nilang manok. magnanakaw ako sa manok ng nanay ko, ang barkada ko magnanakaw sa manok ng tatay niya, pagkatapos ng mangharana, lulutuin yun, and then matutulog na kami. Kung nahuli ang isa magnanakaw ng manok, magkano ang penalty noon? From PAO. From DOJ. Pangsabong, magkano lang ang manok pangsabong noon? Anyway, ang point ko is, ang crimes noon hindi ganon kahinos, hindi ganon kagrabe. Kaya pwede, the revised penal code in my recollection stated December 8, 1930. Ang kalabaw noon, magkano lang? Pag nag-threefold rule ka, hindi lalampas ng 40 years. Kaya okay lang yung 40 years noon as maximum. Pero ngayon, iba na ang mundo eh. Okay? Noong panahon na yon, naririnig ko ang demonyo. Sabi nga, nakakita ka na ba ng demonyo noon? Meron kami naririnig. Meron ding demonyo. Ang asawa pag sumisigaw sa umaga, demonyo ka. Tinatawag niyang asawa niyang demonyo. Yun lang ang extent ng demonyo na nakikita ko. Pero ngayon, talagang grabe na ang demonyo ngayon. I-rape mo. Ano bang makukuha mo? Sasaksakin mo 38 times. Gusto nating ma-rehabilitate. Isusugal mo ba ang buhay mo sa prinsipyo ng rehabilitation? And I am asking, okay, pag-usapan natin ito, Kongreso. How about yung agrabyado? Ang nanay o ang tatay nung ni-rape. At that time, ang pumapatay senselessly, ang tawag namin noon, huramentado. Ngayon, ang dami ng huramentado. Hanggang 40 years lang. Pwede uli maghuramentado. Okay, yun lang. I am compelled to express my view being the author of the bill. By the way, ito yung House Bill 4553. Hindi pa ito GCTA ha. Kaya may tanong ako sa Bucor at sa BJMP mamaya pagdating sa House Bill 4628. Article 70 lang ito. Speaking of rationale, Madam DOJ, Madam Pau, tama ba yung perception ko? Yung revised penal code noon, very relevant pa ang 40 years as maximum. Pero ngayon, sa tingin ko, sobra-sobra na. Your reaction?
Sir, yun po precisely yung aming sinasabi kanina. Yung batas should be adaptable sa times. So, if sa inyo pong paniniwala, hindi na ito responsive, then okay po. Tama po.
Thank you. BJMP, ilang taon ka na, Mr. Rocamora?
47, sir.
Bata mo pa. So, 74 minus 47, pwede na kitang maging anak din. But anyway, 47, at when you were 18, may naririnig ka pa noon na mga serial rapist na pumapatay na nire-rape nila?
Wala akong matandaan, Your Honor. Sa probinsya namin, very peaceful kasi.
Ganon din. Kaya ako, probinsyano din ako, Leyte. Let's go to, is there any other Prosecutor General? Your comment, please.
Mr. Chair, considering that the Office of the Prosecutor General and the National Prosecution Service is merely the prosecutorial arm of the DOJ, we respectfully differ to the findings of the State Council. I mean the Office of the Chief State Counsel.
No comment.
Yes, Your Honor.
Okay, we go to initial consideration. Wala na? Sandali. DOJ, PAW. Tapos na. Okay. You will be submitting in 5 days, Bucor, your position paper. Anybody else who is asking for more time? Ito, ano lang. Okay. So we defer further consideration on House Bill 4553. Honorable Gonzaga.
Thank you, Mr. Chair. My, Mr. DOJ, sir, you mentioned earlier that your opinion is with reservation, right?
Yes, Mr. Chair.
You also read the gist of the opinion of the DOJ, and you have mentioned about the list of PDLs who will not be covered of Section 7, Article 70, particularly the last paragraph. Therefore, your opinion on this matter is, of course, not in favor of the bill subject to legislation, but you have a qualified suggestion or modification on the subject bill, which will run as follows. One, you will not delete the 40 years limit of penalty, but instead, you would like to have list of PDLs who cannot avail of the last sentence of Article 70, right?
Yes, Mr. Chair.
Now, in your opinion, what would be the PDLs who will be the PDLs who will not be covered by this provision, particularly the 40-year limit?
My contemplation of the bill of the position of the department, Mr. Chair, is that, for example, we refer to those PDLs who are convicted and serving multiple sentences for crimes other than heinous crimes.
Okay.
For example, one who have committed multiple crimes of estafa, which is not heinous in
For example,
nature.
may isang offender nang binaril niya 3. Like for example, the case of Mayor Sanchez. Marami siyang na-commit na crimes, rape, many counts, and then subject siya sa reclusion perpetua, 9 reclusion perpetua. Now, if we have to classify the case of Mayor Sanchez compared to one offender na yung commission ng crime na reclusion perpetua, isa lang. O, di ba? Yun ang subject natin. Sabi may isang offender na siyam yung kaso na reclusion perpetua. May isa namang offender na isa lang kaso na sa reclusion perpetua. Yet, pareho sila pagdating sa application na Article 70, right? Pareho sila. So, may isang suggestion si Chairman Veloso na tanggalin natin itong Article 70 last sentence because it is not giving equality to one offender na isa lang yung reclusion perpetua niya. Then pareho sila ng application ng Article 70. Now, dun sa nakita ko na suggestion nyo, reservation ninyo, I think that is really valid. Paano kaya kung gagawa na lang tayo ng list of PDLs na hindi mag-a-apply itong Article 70, particularly last paragraph, the 40-year limit? Now, ngayon, can you give us your opinion, particularly pagdating doon sa suggestion ninyo, the common opinion of the Department of Justice, isasalin nyo na lang doon kung ano yung mga PDLs na hindi dapat applicable sa kanila yung last sentence ng Article 70. Just what we did in GCTA. Di ba, GCTA may exemption. One, recidivist. Second, yung mga PDLs convicted of heinous crimes, escapee, and the recidivist. The habitual delinquents. Okay. Kung ginagawa natin ito sa GCTA, bakit hindi natin pwede gawin ito sa Article 70? Para may win-win solution tayo rito, right?
Yes, Mr. Chair, you are precisely correct. And on further analysis of the position of the department, we have realized that this may be further addressed in the guidelines or the IRR of the law when it will be passed.
Ito.
Yes, Mr. Chair.
Paano naman mapapasa ito kung hindi a-agree ang kung yung karamihan ng members of the committee will not agree with the chairman? Kaya nga, we have to make a very strong stand na ito yung common ground natin to have equality for all. So gagawin natin ito with your cooperation. Yung sinasabi mo na, let us give list of PDLs who cannot avail the provision of Article 70, particularly the last sentence. Now, i-incorporate mo na lang doon yung mga PDLs na hindi dapat maka-avail ng section sa Article 70, last paragraph.
That is noted, Mr. Chair, and we will be submitting a new position paper for this matter.
Okay.
Maybe within 5 days, Mr. Chair.
Within 5 days?
Yes.
Baka na naman.
We will try to submit, Mr. Chair, within 5 days.
Okay.
Considering the importance of this bill.
Okay. Thank you very much.
Sino pa? Meron pa? Honorable Representative Carbin. Meron pa?
The issue or the reservation of the DOJ should be properly addressed on the observance of Article 2 of the revised Penal Code, aside from the recommendations and observations being brought up by Congressman Roel Gonzaga, wherein all penal laws will only be if this bill be approved and be signed into law by the President, would only be made retroactive if it is favorable to the guilty. But for those who were already charged before the passage of this law, it will not be made retroactively. Am I correct? Based on the principle of those who are only favorable to the accused and that of the PDLs, as you have mentioned.
You're correct, Your Honor.
Thank you.
Few questions. First, be assured that the position of the chair is not cast on a lapida. Nag-observe pa tayo kasi ng All Souls, All Saints month. Anyway, would you be amenable if the chair will take the position that excluded, i-retain natin, except yung charged ng heinous crimes? Or convicted ng heinous crimes? Kasi yung charge, ayaw ko doon sa charge. There are a lot of, naniniwala ko sa justice system natin dito na palpak. Ang daming nakukulong, nakukonvicted pa nga. Ang iba, charged pa lang, parang guilty na. Convicted of heinous crimes. Kasi when we come to the point of sentencing an accused, pinag-uusapan natin, pag sinabi mo kasi penalty, tapos trial na yan judgment day na yan. Magiging final pa yan upon affirmation, whatever. Heinous crime, convict, to be excluded. All will agree. Pau. I-retain natin.
You mean to say, Your Honor, i-exclude for the application of Article 70 as suggested by the DOJ? Yes, Your Honor.
Okay. Uh, Oka. Sa bagay, hindi kayo pre-preempt. DOJ.
We agree, Your Honor, but I would like to bring up another consideration. If ever a convict sentenced to a heinous crime will truly be reformed and rehabilitated inside the bilibid, will it matter?
Alam mo, puro tayo na nanaginip niyan eh. Ang lahat ng mga may asawa dito, na lalaki ha, ilang beses nang nahuli. I'm not saying sila lahat. Ilang beses nang muntik nang hiwalayan ng asawa niya, magre-reform. Only to find out na nagre-reform sa ibang babae. Now, seriously, no? Ang problema lang kasi ng chair as author is this. Nandiyan na nga yung threefold rule. Huwag mag-exceed ng threefold ng penalty. Beneficial for non-heinous crimes. Beneficial sa mga mabababang crimes. Pagdating mo sa heinous crimes kasi, nag-threefold rule ka, of course, kahit dalawa lang yan, mahirap na niyang malusutan yan. Threefold pa. Kung ang 40 years, gawin natin not halimbawa, but in no case shall penalty be imposed upon a convict who is at the least 60 years old. Marami kasing mga modifications na pwede natin pag-usapan. Ang point ko is, paki-submit nga ng mga possibilities where we can tone down the effect ng proposal ng chair na i-delete ang 40 years. Pwede yung last paragraph, tanggalin na lang talaga kasi yun ang pinakagrabe. Regardless of anong effect ng threefold rule, it should not exceed, ang mayayari dyan, it should not exceed 40. So one is, exclude natin ang heinous crimes, convicts, not charged lang ha. I am not interested so much about the preventive aspect of incarceration, but yung final judgment na. Doon sa recidivist naman, especially if it involves petty crimes, nag-shoplift ka lang. Are you saying hindi ka na pwede? Pero this is proper na in relation sa GCTA. Pag-submit lang to the chair, PAO, State Council, DOJ, Bucor, Prosecutor's Office, ano ang mga possibilities by which we can substantially meet the constitutional mandate that no person shall be deprived equal protection of the laws. Kasi ang iniisip ko, whatever we pass here will eventually be challenged before the Supreme Court. Yan ang magiging focus Ano bang kasalanan nito at bibigyan mo lang siya ng ganito, karumaldumal lang ginawa, ako, isang krimen lang, pareho na ang number of years of incarceration namin. Okay? So, in the light of the non-submission yet of Bucor. Sino pa yun? Consideration of House Bill number 4553 is deferred. We go to, siguro, tatapos natin kagad nito. GCTA. House Bill, sandali. We have I am saying GCTA because there are so many authors here. We have House Bill 1614, authored by the Honorable Representative Neptali Gonzalez II. House Bill 1746, authored by Honorable Representative Villafuerte. House Bill number 4383, authored by Honorable Representative Pablo John Garcia. Honorable Representative Chudorico Haresco as author of House Bill 4456. House Bill 4628 of the Chair. House Bill 4715, authored by Honorable Representative Lucy Torres Gomez. Honorable Representative Jonathan Flores on House Bill 4822. House Bill 4894, authored by Honorable Representatives Eric Yap, Jocelyn Tulfo, and Rowena Taduran, and House Bill 4964, authored by Honorable Representative Rufus Rodriguez, Senior Vice Chair, or Vice Chair. We proceed to our resource persons, DOJ.
Good morning, Your Honors. Good morning, everyone. The department is still in the process of finalizing its position paper. Actually, for all the bills, proposing to amend the RPC as regards the conduct of good conduct time allowance system. So we will submit the signed position paper as soon as possible, Your Honor.
Okay. Pao?
Mr. Chair, we have submitted our position paper on last October 31, 2019.
National Prosecution Service.
While we will defer for whatever views that will be expressed by the Office of the Secretary, we have submitted our position paper on behalf of the Office of the Prosecutor General.
You also invited the PNP. Nobody represents the PNP. Okay.
Good morning, Mr. Chair. On the part of the PNP, Your Honor, we have not yet submitted our position on the matter, and we respectfully request for additional time to submit the same. Maybe next week, Your Honor.
How many days? 7 days? 5 days?
7 days, Your Honor.
Okay. Bucor?
We would like to make a manifestation, Your Honor, that the Bucor was invited with respect to the GCTA and not with respect to House Bill number 4553. That's the reason why we haven't submit any position paper with respect to the earlier House Bill. With respect to the GCTA, that's the plea of the Bucor a while ago that may we given 5 days to submit our position, Your Honor.
Thank you, BJMP.
Mr. Chair, Your Honor, the BJMP has already submitted its position paper on the 9 bills pertaining to the amendment of GCTA law.
COMSEC IBP has it submitted already its position paper?
Your Honor, the IBP has not yet submitted their position paper.
Okay, I see no representative from the IBP. Uh, The committee also invited resource persons from the OSG on this matter. Is there any have they been served the invitation, Comsec?
Yes, Your Honor, the OSG received our invitation. However, they sent a letter stating that they are unable to submit their position paper for today, and they are requesting an additional period of 20 days or until November 24 within which to submit their position papers, Your Honor.
Okay, that being the case, the chair defers any additional manifestation on the part of the DOJ? Nagsabit na kayo, di ba? Can you articulate your briefly?
Mr. Chair, I believe that the DOJ, on behalf of the Office of the Secretary, was not able to submit a position paper. However, on the part of the Office of the Prosecutor General, we were able to submit a position paper.
Sino pa? So, yes or no?
Yes, Your Honor.
So you support the bill?
We have certain matters that were expressed in the position paper.
What is the position, in a nutshell, what's the position of the National Prosecutor?
Yes, Mr. Chair, we support the amendments to the articles under the revised penal code relating to the time allowances.
So you support?
Yes, Mr. Chair.
BJMP?
Yeah, yes, Your Honor. If you may allow me to read our position paper, sir.
Ay, mahaba pa masyado?
No, sir. That's the preliminary, sir. 2 paragraphs.
Okay.
This consolidated position paper is being submitted to the chairman of the Committee on Justice, the Honorable Vicente Ching Velasco III, concerning the amendments to Article 29, 75, 94, 97, 98, and 99 of the revised Penal Code in the application of the Good Conduct Time Allowance to PDL, proposed by members of the House of Representatives. It is evident that there are ambiguities under Republic Act 10592 and its IRR that created confusions among agencies of the government implementing and applying it. In this regard, the BJMP strongly supports these House bills to rewrite the law in a clear, concise, and unmistakable language, free from any ambiguity or confusion. One of the primary and basic rules in statutory construction is that where the words of a statute are clear, plain, and free from ambiguity, it must be given its liberal meaning and applied without attempted interpretation. Further, the BJMP humbly recommends House Bill number 4628 as the working draft for simplicity and brevity. Considering further that the grant of good conduct time allowance under the proposed draft bill shall be left to the sound discretion of the court, who has original jurisdiction over the case and who has retained vested power and authority in carrying out the court's decision. The court's jurisdiction was not terminated by the commitment of the convict to the jail authorities. The commitment was but the start of carrying out of the court's decision. It is the prerogative of the court meting out the punishment to see to it that the punishment be served until the act of lawfully unauthorized administrative agencies of the state, the convict is pardoned. The convict is pardoned or paroled or lawful grounds act as liberty, set at liberty sooner than the expiration of the sentence imposed. That's all, Your Honor.
Sino pa? None more. Uh, Relative to the position of BJMP, that it should be the court should order the release of the convict. Ilan ang hindi abogado dito? You're all lawyers, di ba? Okay. Mas maganda pag-usapan ito. Basic are the following. One, jurisdiction is fixed by law. It is not subject to agreement of parties. Number two, jurisdiction once acquired must continuously be exercised by the court that acquired jurisdiction over the accused, or even in civil cases, over the case. It must be exercised until the final termination of the case. Number three, in a criminal case, when is the case finally terminated? The case is finally terminated when the convict has fully served his sentence. Okay. It is in this regard that the chair as author proposes, with due respect to other agencies, even to the Office of the President, to the Secretary of the Department of Justice, it is in this regard that the chair proposes that only the court can order the release of a duly sentenced convict, because it is only the court that can judicially determine and resolve the question of whether or not that convict has fully served his sentence. There are a lot of cases already that went as far as the Supreme Court, be it in labor case, civil case, in criminal case. There was, I recall, a case of Department of Foreign Affairs versus NLRC. ICMC, International Catholic Migration Commission, is a specialized agency of the United Nations. May tinanggal na empleyado ang ICMC. ICMC is a specialized agency tasked to help this Vietnam boat people. Anyway, tinanggal isang empleyado, nag-file ng illegal dismissal case. Natalo ang ICMC. The decision became final. No appeal was made to the Court of Appeals. It did not go to the Supreme Court. So may entry of judgment na. Nag-file ang Department of Foreign Affairs ng motion to set aside the decision on a question of jurisdiction. The Department of Foreign Affairs said, in the first place, the NLRC did not have jurisdiction over the case because specialized agency of the United Nations is exempt from suits like this. And what did the Supreme Court say? On the question of whether or not it can entertain the case at the so late level sa kanila, Supreme Court said, enforcement of a judgment is the last stage of the court's exercise of jurisdiction over the case. So at that point, ini-force ang judgment ng NLRC, kini-question ng DFA. sabi ng Supreme Court, we can entertain this case on the ground of lack of jurisdiction. The jurisdiction that was not present at the initial stage of the case is the same lack of jurisdiction that actually bars the enforcement of a judgment of the NLRC. Similarly, pagdating sa criminal case, a convict sentenced to suffer imprisonment can only be released by order of the court when upon full service of sentence. When can you say that the convict has fully served his sentence in relation to good conduct time allowance? Papasok dyan ang mga formula. But who will order? The court. Who will recommend? It is the view of the chair as author that the custodian of the convict must recommend, must compute, subject to the final determination by the court if the computation on GCTA was proper or improper. So, yun in a nutshell is what House Bill 4628 and may mga House bills pa rin yung colleagues ko dito sa Congress. Honorable Taduran. Do you wish to add anything?
Thank you, Mr. Chairman, and good morning to my distinguished colleagues. In behalf of Congressman Eric Goyap and Congresswoman Jocelyn Puwatulfo, may we ask this august body to consider the explanatory note of House Bill number 4894, otherwise known as an act defining good conduct and providing conditions in the grant of good conduct time allowance, further amending for the purpose Article 97 of Act number 3815, otherwise known as the Revised Penal Code, as amended by Republic Act number 10592 as our sponsorship. Thank you, Mr. Chairman.
Okay, nothing more. Pending submission of the required position papers, we have to reschedule our deliberation on the House bills in good.
Mr. Chair.
Comfortun.
Pahabol lang, Mr. Chair. One question lang sa DOJ. I understand you had a joint effort with the DILG to amend the IRR of the current GCTA law. Meron kayong ginawa, di ba? DILG and DOJ.
Yes, Your Honor.
You're done with it, correct?
I think, Your Honor, it was signed and published in September of this year.
Okay. Can you please furnish the committee a copy for our guidance?
Yes, Your Honor.
Thank you, Mr. Chair.
In connection with that, Mr. Chair, can you please enlighten the committee what was the salient features of the DOJ's recommendation on the amendment of the IRR?
I apologize, Your Honor. The representations here were not part of the team that revised the IRR, so we cannot.
But if you have any idea, would that include the sending a notice or informing the family of the victims about the grant of GCTA on the convict? Kasama na ho ba doon sa IRR?
Good morning, Mr. Chair. Good morning, Your Honor. We upon initial browsing of the amended implementing rules and regulations, we cannot yet confirm if it's included in the revised IRR, but we will be furnishing a copy of the same.
Copy of the
Yes.
revised IRR.
Yes,
Thank you.
Okay, the Honorable Waminal has
Thank you very much, Mr.
floor.
Chair. This is just an administrative matter. As part of the House leadership, this representation commends the chair and the members for the orderly manner and the best handling of this committee hearing today. And this representation would just like to commend also the responses of the resource speakers, but take exception of this observation, Mr. Chair, under our roles, whether the attire of State Counsel Attorney Ulysses Aguila is proper. If it is proper, there is no problem with this representation. And if it is not, let this observation be part of the committee observation and be forwarded to the Secretary of Justice for his proper guidance in the future invitations of this committee. However, under our roles on what we call the due process, Attorney Aguila can shed light if ever he wants to respond to the observation of this representation. Mr. Chair.
Attorney Aguila.
Apologies, Mr. Chair and the members of this committee, but I believe the Barong Tagalog is an acceptable attire during hearings. However, I'm not aware if a short sleeve Barong Tagalog is. But apologies, Your Honor, for this matter.
That is why, Mr. Chair, we recognize the humble response of the good State Counsel. That's why I'm referring to what is the customs or the roles insofar as attire in appearing before the committee and before the House of Representatives. I yield and submit to whatever be is the standard acceptable insofar as the practice of the committee and the House of Representatives is concerned, Mr. Chair.
Offhand, 17th Congress, the Speaker himself at that time would be seen in not, by the way, in court, there are only two attires you can resort to. You can wear barong or coat and tie. In fact, I recall 70s yung mahahabang mga buhok namin. I was fined for sporting a long hair. That is a matter that has to be decided upon. And I think the Deputy Speaker can help the chair on that. Plenary, we have to wear coat and tie or barong. I think that is what was announced on the floor. Committee hearings, the Deputy Speaker has to educate me on that because I'm not, many times, 17th Congress, I rarely would see the chairman of the Committee on Justice, then Representative O'Malley, sporting tie, palaging naka-ganito yon. And really, when you are not so young, you feel parang nasasakal ka if you wear a tie, especially kung medyo lumaki na yung leeg mo. Hindi na magkasya, hindi na, tingnan mo, hindi maboton yung ano ko. So, if I have violated any rule, my apologies. My first problem is I cannot really button my shirt sa leeg, tingnan mo, without choking me. Any most important motion?
Mr. Chairman, I move that we adjourn.
Having been moved, seconded, meeting is adjourned. Ikaw kaya mo pang mano, ako talagang hindi.
Mas gwapo ka kasi pag